I'm Vinnie Politan. Great to have you with us here on Closing Arguments. And things have been going incredibly well inside the courtroom in Minneapolis. It's day 2 of jury selection, and Judge Cahill, the attorneys, the prospective jurors, I mean, it's like clockwork inside that courtroom. 2 more jurors added, so we're up to 5. That's a big story. And these jurors are pretty impressive. Hearing their answers and what they do and how they see the world, really interesting stuff. These are the folks who will decide whether or not George Floyd was murdered. So this is a very significant part of the case. It's been going well. It's the case that a lot of people said you'll never find a jury, but we're more than 33% there. So that is continuing. And we're going to talk about these jurors, and we'll find out more about them and analyze them a little bit. But there's another part of the news today from Minneapolis, because one of the other issues in the case are the actual charges against the defendant, Derek Chauvin. All right, we know he's charged with second-degree murder, facing up to 40 years. He's charged with second-degree manslaughter, facing up to 10 years. But prosecutors want another charge reinstated, which is third-degree murder. They originally put it in there. The judge dismissed it, and then the litigation began. Prosecutors appealing to the Appellate Division, the Appellate Division making a ruling, sending it back down, but then the defense appealing that to the Minnesota Supreme Court. So it's really kind of was up in the air. What exactly are the charges in this incredibly big case, incredibly important case that is, you know, almost selecting a jury, and we still don't know the exact charges at this point. But today, the Minnesota Supreme Court has spoken, and of course, it's my biggest moment of the day.
Yep. I know exactly what you're going to talk about. Let's hold off on the next. The next is a group advisory in any case. It's a group advisory to begin with, but we want to talk a little bit first. Okay, that juror has left. Mr. Nelson, I think we're talking about the same thing. Everybody check their email. It appears that the Supreme Court has denied review of the defendant's petition for review of the Court of Appeals opinion. I think we can talk about this tomorrow morning at 8 a.m. On its effect. I think we still have the jurisdictional issue with the Court of Appeals.
All right. Some legal mumbo jumbo, right? The Supreme Court has denied review. What does that mean? How does that impact this trial? And how does it impact the charges that this jury will have to decide? Let's bring in Court TV legal correspondent Julia Janae, who is live in Minneapolis, Minnesota tonight. This is big breaking news. Amazing. We're in jury selection in this enormously big trial. Our cameras are in the courtroom, yet my biggest moment tonight is something that didn't even happen in this courtroom. So, Julia, explain to us the significance of what the Supreme Court of Minnesota said today and how that could impact everything else happening in this trial.
This is all about the third-degree murder charge, that lower-level murder charge that the state has wanted to get in against Derek Chauvin, something that was dismissed last year, and they've been seeking to reinstate it. And today, we heard from the Supreme Court here in Minnesota, not the U.S. Supreme Court, but it's the highest court for this case, and the defense was trying to get that court to review this issue because they didn't get a favorable opinion from the court that's in the middle, the Court of Appeals. That happened on Friday. But now that we know the Supreme Court isn't going to rule on it, or they're not going to even hear arguments, that means what the Court of Appeals decided is final. And they decided that the state was correct in believing that Judge Peter Cahill should not have dismissed that charge. So it's a lot of litigation that's been going on. Here's a look at the precedent case, the Mohammed Noor case here in Minneapolis that is at the heart of this and how we got here.
George Floyd is not here. He should be here. He should be alive, but he's not.
In a motion filed by the Attorney General's office, the state demands that the court reinstate the third-degree murder charge against defendant Derek Chauvin, saying there's new precedent based on another Minneapolis officer-involved death.
The Mohammed Noor decision that came out from the Court of Appeals is pretty significant in the sense that it suggests perhaps it might be possible to be able to add additional charges in terms of the prosecution.
2-1, the Minnesota Court of Appeals upheld the third-degree murder conviction of Minneapolis police officer Mohammed Noor. In 2017, Noor fired his gun out of his squad car window, striking and killing Australian native Justine Damond. The encounter happened in a dark alley. Noor and his partner said the unarmed woman startled them. Despite having different facts, University of Minnesota law professor David Schultz says Noor's case impacts Chauvin's.
Probably two of the most controversial cases in recent Minnesota history in general, and especially involving police officers, are now completely intertwined together.
Chauvin faced 3 charges last year: second-degree unintentional murder, third-degree murder, and second-degree manslaughter. In October, Judge Peter Cahill dismissed the third-degree murder charge, citing Chauvin's use of his knee to restrain Floyd's neck as not being, quote, eminently dangerous to others who were in the area, which the judge says is a requirement under Minnesota law for third-degree murder.
To a degree, Judge Cahill, who really is a fine judge, he straightened it out by getting rid of the third-degree murder, which never had any business being in there in the first place. They have him charged with unintentional felony second-degree murder arising out of the commission of a felonious assault. That's what it is. It's called felony murder. If you commit a felony on somebody and you don't intend to kill them, but they end up dying, that's unintentional second-degree murder in Minnesota.
That analysis is now under scrutiny after the Court of Appeals found Noor committed third-degree murder even though his death-causing act was directed at a single person. For Attorney General Keith Ellison, this ruling in Noor opens the door for the state to add third-degree murder charges in the case of co-defendants Alexander King, Thomas Lane, and Tu Tao, and resurrect third-degree murder in Chauvin's case. And we know that the Court of Appeals on Friday, they ruled that Judge Peter Cahill, who's over this murder trial, that he does have to follow their ruling in the Noor case, and he has to treat it as precedent. So these parties are going to come back in the morning on Monday, and Judge Cahill will have to reconsider his decision in third-degree murder. He'll hear more arguments, and he'll have to make a ruling. He doesn't have to 100% accept the third-degree murder charge, but he has to take everything under consideration, and he has to accept that the Mohammed Noor case is precedent for this case.
And there's a couple big aspects of this. Number one, it makes the scheduling of this trial seemingly much more on solid ground. I mean, we didn't know what the Supreme Court was going to do. If they took this up, it could have thrown a monkey wrench into the entire case and trial going forward. But now it looks like, at least from my perspective, that there's a much better chance right now after this ruling that the trial will go forward, because the judge now has jurisdiction over that third-degree charge. Or does he have jurisdiction yet? When does he get it from the appellate court?
That's a great question. The appellate court will have to enter a judgment. So even though they've issued their decision, their opinion, something that we can read online, they don't put in a final judgment until the Supreme Court either weighs in or the period of time for someone to go to the Supreme Court passes. So we can assume that now that the Supreme Court has weighed in, they do not plan to take up this issue. The Court of Appeals can now put in that judgment, and then jurisdiction would pass back to the district court. But even Judge Cahill said there is still this outstanding issue of jurisdiction and the writ of prohibition that the state tried to file on Monday, trying to get jury selection off track and halted while they waited for this to happen.
And that didn't happen. That seems like it's moot at this point, because one of the reasons to halt it was because it could take the Supreme Court a long time to figure this whole thing out, but they're not going to deal with it. They sent it back down. So it seems it's just a matter of the appellate court entering the judgment, Judge Cahill now getting jurisdiction over this issue and making the decision one way or the other based upon the ruling of the appellate court, whether or not third degree comes back in. Now, he could still deny it for a alternative reason if, in fact, the defense makes some sort of alternative argument, which I would expect them to do.
Well, we know Eric Nelson is a great attorney, and he is going to find some kind of argument that he hasn't made before, or one that he wants to emphasize more for the judge to weigh when he's reconsidering his own decision. So that has yet to be seen. We'll know in the morning. And on those other issues that, yes, they do now seem moot, but they've got to be filed. I'll be up all night checking those dockets to see when these judges put those entries into the court file.
Unbelievable, but I think it's the best news for people who want this trial to go forward. By the way, this whole issue of this third degree, which seems to be a very, in the weeds kind of legal issue, but one of the prospective jurors today actually heard about it, and it came up in court. Let's take a listen.
We understand, however, that maybe inadvertently you may have seen a headline or seen something on TV briefly, anything like that that has added to your knowledge about the case.
No, just the headlines. I've tried to avoid beyond the headlines.
Okay.
And the only thing that's probably come up in the headlines is the news about third degree.
Okay. And what do you remember about that? About the substance of what either the headline said or?
That it's something that the perhaps the prosecution would be in favor of, and adding that as an option, and that the defense maybe would not be as in favor. That's my headline impression.
Okay.
Julia, you know what's amazing about what we just heard, and that juror didn't make it onto the jury, is that I get a lot of very cynical attorneys as guests on our show here about jurors and whether or not they trust them. And here's another example, right? This is a juror who is self-reporting something that he heard about the case. To me, it's amazing how honest they are during this question and answer, this voir dire. And even during the course of the trial, we've seen many times where jurors may have heard or saw something that maybe I shouldn't have, and they tell the judge.
A lot of candor we're hearing from these jurors, and an appreciation for the system. One of the potential jurors today used the term magnitude of the case, that he understood just how important this was. And you do hear them self-reporting, saying, look, something may have popped up on Instagram, or there was a friend who told me something. They want to make sure that the judge knows anything that they know about the case, and they allow these attorneys to help them flesh it out to see if it's something that's going to impact whether or not they can sit as a juror.
And that's why I presumptively trust the jurors, unlike my guests.